today we are discussing about the confession made before the court. The confession, it may be, the confession can be made by anyone. It can be by the complainant, accused, or by some other person. It may be oral, written, or by expression. Right now, Section 24 and 28 of the Evidence Act provides the condition for relevancy of confession, providing that in the opinion of the court, confession confess the cause caused by inducement, threat, or promise. That is called at ITP. But Section 28 of the evidence provide that if the same has been done without ITP, removing the ITP, then it shall be made applicable, it shall be admissible under Section 28 of the Evidence Act. But the relevancy is it has to be made without inducement, threat, or promise, and that has to be assessed by the court. The assessment has to be done by the court. So Section 24 and 28 of the Evidence Act provides confession that can be made by any person before the court, and it provides admissibility or non-admissibility of it as indicated above. The voluntariness of the confession has to be satisfied by the court during the investigation under Section 164 of CRPC, and during the trial, if it is tribal-wise session, under Section 229, 231, 233 of the CRPC, and if it is trial by, and in a warrant case, and in the trial of warrant case, it is under Section 241, 242, 243 CRPC, and in the trial of and in the magistrate trial, it is under Section 252 of CRPC. In the session, in the summons trial, in the summons trials, it may be under Section 252 of the CRPC. The confession can be kinds of confessions are there. It can be judicial confession, or it may be extrajudicial confession. So what is the relevancy of confessional statement of the accused? Relevancy of confessional statement of the accused. We are talking about this topic. Section 25 of the Evidence Act provides that no confession made to a police officer shall be proved as against a person accused of any offense. Person accused of any offense, but the said confessional statement to the extent of recovery of incriminating articles under Section 27 of the Evidence Act shall be admissible. The confessional statement of the accused recorded by the police is not admissible in the evidence, but to the extent of recovery of incriminating article, it is admissible under Section 27 of the Evidence Act. Further, 26 of the Evidence Act provides that the confession of accused while in custody of police, made in the immediate person, in immediate presence of a magistrate, is admissible in the evidence against him, which it means that if the accused is making confession of any fact before the police in presence of any magistrate, though it is confessed before the police, but it is in presence of the magistrate, therefore it is admissible in the evidence. Otherwise, if it was independently made to the police without having presence of any magistrate, then it is not admissible in the evidence under section 27(5) of the Evidence Act. But similarly, if it is made before to the police in the immediate presence of the magistrate, it shall be admissible in the evidence under section 26 of the Evidence Act. Because the basic concept of non-admissibility of confessional statement of the accused recorded by the police is, in the law, it is the presumption in the law that the person who is in police custody is always remain under threat and pressure, and his statement recorded by the police cannot be said to be independent between a statement. It is always treated that it has been obtained after threat or coercion. So it is presumption under the law. And the said presumption will be removed if the said confessional statement has been made to the police in presence of any magistrate. The further, section 29 of the Evidence Act provides confession of accused before anyone is relevant, although it is made by him under a promise of secrecy or in sequence of deception practice on the accused persons for the purpose of obtaining it, or where he was drink. It has to be the section, the section 29 basically provides the extrajudicial confessional statement. If someone is coming before anyone and confess about commission of any offense, then it is admissible under section 29 of the Evidence Act if it is proved by such person before whom it is made. So it talks about admissibility of extrajudicial confessional statement. Section 30 of the Evidence Act provides consideration of proved confessional statement of the accused when more persons than one are being jointly tried for the same offense. If more than one accused are being tried for the same offense, one accused appears before the court and he confessed the commission of offense by him as well as by the co-accused. The said confessional statement of the accused before the court is admissible in the evidence against him, but it may be admissible against the co-accused also if after the completion of proceeding under section 145 of the Evidence Act. It shall not be applicable against the co-accused unless he is put for cross examination by the co-accused, and it may be used, the said confession may be used before the co-accused person after compliance of section 145 of the Evidence Act. It is not always applicable, but it may be considered as an evidence against the co-accused as provided under the Act. The section 31 of the Evidence Act provides, section 31 of the evidence provide that the admission not conclusive proof, but may stop. It amounts the admission of any accused either before the investigation agency under section, either before the magistrate under section 164 of the CRPC during investigation, or before the court of law during the inquiry or trial. It shall not be, though it is admissible in the evidence, but it shall not be conclusive proof for deciding the trial. It may be, or it shall be, it may or it shall be used as an evidence, subject to the consideration of other material and other evidence available on record. We can take one example. If somebody committed murder and thereafter he menaced anyone and produced before the court who confess about commission of offense by him, he tried to prevent his relative or someone, main culprits. The question will be whether the confessional statement of the said person shall be conclusive proof, though it is telling lie before the court, which is evidently clear from the other circumstances and the evidence on record. In that scenario, the court can ignore it, and court can proceed to decide the trial on the basis of other evidence available on record. So the confession on the confessional statement can be made by the accused during the trial under section during investigation under section 164 of CRPC. Under investigation under section 164 CRPC, and during the inquiry or during the trial, it can be under section 229, 231, 233 in the session trial, and under section 241, 242, 243 CRPC in the trial of the warrant cases, and under section 252 CRPC in the trial of the summons case. So we are further talking about the admissibility of the confessional statement, whether the confessional statement can be alone sufficient for deciding the trial, ignoring the other evidence available on the record or other circumstances which are appearing on the record. This confessional statement cannot be conclusive proof of evidence, though it can be used for consideration of all the things, all the evidence available on record, but it may not be conclusive evidence as defined under section 131 of the Evidence Act, as well as the settled law laid down by the Honorable Supreme Courts. So far as concern of the confessional statement of the accused, there are leading cases of Honorable Supreme Court, that is State of UP versus Devman Upadhyay 1960 AIR 1125, and another leading case is Agnew versus State of UP 1966 AIR SC 119. So the confession are in two parts. As we discussed earlier, the confession can be made by any person before any court of law. Take an example. If a trial of any offense is continued in any court of law, in session trial or any magistrate trial, some accused have been charged for commission of offense. Trial is being proceeded. Any person who is the relevant witness, but he has not been made witness during the investigation, he is not witness on record, but he is actual eyewitness. After coming to know about the continuation of trial about the said offense, the said person appears before the court and confess the occurrence in the manner in which it was happened. The evidence, the said confession of the witness, though it is not produced by the prosecution or by the defense, but it is the independent witness that himself appears before the court. The statement, confessional statement of the said person who is independent person, independent witness, shall be relevant for deciding the issue, as he is the material witness. And thereafter it has to be assessed by the honorable court regarding the applicability of that, regarding its applicability. And if the honorable court is using it, then it has to be corroborated by section 145 of the Evidence Act, and the aggrieved person may be provided opportunity of cross-examination. And after being cross-examination by the aggrieved person, the said statement, confessional statement, may be used for deciding the issue involved, deciding the issue of commission of offense. So the confession can be made during, and we are further talking about the confession made during the investigation. So far as concern of the confession made before the investigating officer, that is not admissible in the evidence as under section 161 of the CRPC. But if it is recorded, it is made under section 164 CRPC before the magistrate, and the magistrate satisfied himself under section 164 subclause 1 of the evidence in CRPC, then it may be admissible in the evidence. Further, after concluding the investigation, the confession can be made during the inquiry or during the trial. The accused can always, the accused can always confess the commission of offense during the trial. In the case, in the session trial, the accused can in the session trial, Mr. Gaurav, please help me about the session trial. Yeah, this is guilty. In the cases of the session trial, section 229 of the Evidence Act CRPC provides conviction on plea of guilty. So the accused can admit his guilty under section 229 of the CRPC, and similarly he can confess the commission of offense under section 313 CRPC also. And similarly, in the offense of warrant, in the trial of the warrant cases, the accused can confess guilty under section 241. That will be called as confessional statement. And similarly, in the cases of the summons trial, it can be under section 252 of the Evidence Act of the CRPC. So we have already discussed the confessional statement of the accused. Though it is admissible in the evidence, but it may not be conclusive proof of the evidence. It has to be analyzed by the honorable courts very carefully, because in some of the cases it may be the false and incorrect, as there is some otherwise evidence for commission of the offense. There is some credible evidence for commission of offense, but the accused in order to save some other person appears before the court and admits his guilty. He may be false. And he's trying to defend someone else. So in that scenario, in that circumstances, the court can ignore it, because it has to be tested by the honorable court. Because as the confessional statement of the accused cannot be, as we have already discussed, that the confessional statement of the accused cannot be the sole basis of deciding the trial.